under President Clinton, Congress passed and he signed DOMA, the Defense of Marriage Act. Defense of Marriage Act blocks recognition of any marriage except marriages between a man and a woman. It blocks it for federal recognition in every category. Immigration is a complete federal category only, it's not a state category. So DOMA blocks for immigration recognition purposes the recognition of any marriage between a same-sex couple. So even though it's now legal in 3 states, I guess, or 4, and even though there's also unions that are recognized, even though it's legal in many other countries, and foreign marriages are recognized if it's with a straight couple, DOMA blocks that. GLAD is challenging DOMA, but not this piece right now, and I'll explain why. GLAD is challenging DOMA for all the benefits, and there are, I think, around 3,000 benefits that you can get from marriage. GLAD is challenging the denial of a number of those benefits to people like surviving spouses, widows or widowers, persons who have been injured at work, people who are not able to get access to retirement benefits, people who are not able to file tax returns as married in the federal system, and on. There's all these different ones. And it's in federal court. It's moving along apace, which is always very slow in federal court, but there's a good chance they drew a very good judge at the district court level. And there's going to be a battle there and probably a trial, and there's a good chance they'll win, we hope. If they lose there, they'll appeal to the First Circuit Court of Appeals, and if they lose there, they'll appeal to the Supreme Court. The other side is going to do the same thing. So this is a huge case that is certainly going to go all the way to the Supreme Court, unless DOMA gets overturned. There's some growing effort to do that, but I don't know if that's going to work. They haven't challenged on the immigration side for this reason. Immigration is totally federal, but on top of that, on any challenge to immigration rulings, the federal courts almost always defer in interpreting a law or accepting a law as constitutional when it affects people who are foreign nationals. They defer because there's parts of the Constitution that says that really is the authority of the executive to interpret the law and apply it in dealing with foreign countries, and Congress's power to make the laws which the executive will apply. And the courts don't step into that the same way they would if it was a marriage between 2 citizens of the United States. So that deference which the courts give in the immigration area is so total that they have upheld discrimination on the basis of race, nationality, the section of the world you come from, whether you were born in or out of wedlock, whether it was a petition by a mother or a father at various points, whether they recognize divorce, etc. There is a really ugly history going all the way back to the first President Adams from Massachusetts with the Alien Sedition Acts, upholding things that otherwise would not be legal or not constitutional in the United States. So virtually all the law professors and practitioners who have looked at this felt that an attack on DOMA by GLAD on the immigration issue would be the weakest link, and it would likely give the right wing a chance to win a peace, which then might jeopardize the rest of the victories. So the strategy is try to win on the other areas where it seems pretty clear that every court that's been looking at discrimination against gay people has found that it's not constitutional, that you might have a chance that the federal district judge here and then maybe the appeals court would go our way, but not as likely, not nearly as likely that they would do so in the immigration area. However, if we win on one area, then it opens the door for more litigation, including in the immigration area. So the idea is keep moving forward politically if at all possible, but move forward in the litigation in the areas where there's a reasonable chance, no guarantee here at all, but a reasonable chance of victory, and then open up the door to a challenge of DOMA for immigration benefits, where at the present we would probably almost certainly lose. Even with a good liberal federal judge, there's a real chance we'd lose. So at this point, if you are married to a person of the same sex, and you are a U.S. citizen, and you file a petition to sponsor your spouse, it will be denied by the Immigration Service. And then it would go, if you appealed it, it would go to the Board of Immigration Appeals. It will be denied by the Board of Immigration Appeals, and you would then have to appeal it into the federal courts. and you'd be in the same situation GLAD is challenging DOMA, but you'd be alone and you'd be facing really bad law, not just DOMA, but this deference to Congress and doing things that are really ugly discrimination and have been upheld for over 200 years. So our feeling is that go ahead and get married if you want to, but you should check out whether that would jeopardize any other immigration status. Because, just as a side note, if I marry my boyfriend and he is here as a student, he has to prove to the government, sometimes repeatedly, that he intends to go home to Italy. He does not intend to stay in the United States. If he's married to me as a U.S. citizen, there's a good chance he's not going to want to go home, or not go unless I want to go to Italy. Could be good. But you know, let's say it's some country where there's a civil war, or where there's poverty that's extreme, or there's discrimination against gay couples. It's even less likely he can prove that he wants to go home. So if you're in a same-sex relationship and you add to it the marriage piece, and that comes out, it may not come out. It isn't clear that it has to be revealed. But if it does, the very fact of the marriage might defeat my spouse's ability to prove non-immigrant intent, that is the intent to go home in obedience with the student visa law, the visitor visa law, etc. So you want to be very careful, check with an immigration attorney before the marriage to determine that the marriage would not jeopardize the present immigration status, because it's very clear it will not give an immigration status. It's not going to give a benefit. In the cancellation of removal that I mentioned, extreme and extraordinarily unusual hardship to me, the spouse of my boyfriend, now my spouse, is irrelevant under the law because they won't recognize the relationship. So he's not going to get anything out of marrying me on the immigration side, and he might get a jolt in the wrong direction. So you definitely want to have consultations first with an immigration attorney before the marriage to determine whether or not there would be harm from it rather than benefit. I think the good news is the litigation that GLAD's going right now is going well. The good news is even though there's been some defeats recently in Maine and New York, there's a lot of positive momentum in favor of protecting gay and lesbian rights. There's also good news on the transgender front in that the Board of Immigration Appeals recognizes transgender marriages if, as a result of the operation, there is a male-female relationship. So it's not super broad, but it's much better than the law used to be, and that's recognized nationally now. So there have been some significant victories. The elimination of the HIV exclusion is huge. I mean, I don't think 2 years ago we thought it was possible, even though a lot of people were working in the background to change it. On the other hand, we still have DOMA, and we still have an immigration system that's broken, that millions of working people who just want to have a life here in the United States cannot get into any line which will allow them to be legal. They won't be hurt by the HIV exclusion anymore, but they do need we do need comprehensive immigration reform.